All right, Jillian, can you do a mic check with me, please?
Can you hear me?
Yes, I can hear you. Hopefully channel 20 can too. All right, someone just came on the line.
Yes,
but I don't know
hi.
who that. Hi, who's this?
Is Renee Clark.
Oh, hi. Let me change
Hi,
your
Gina. I
screen name on
recognize your
here.
birth. Okay.
Let me just change your screen name so that I can. Okay, so let's do a mic check with you. Okay, they said that they heard you.
Oh, very good.
We have 1 minute to live and we don't have either of the attorneys here. Okay, great.
All right.
Mr. Shore? You have
Yeah,
an Android?
I'm just testing these buttons. I haven't done one of these, so
Oh,
I see my
okay.
hand.
You're welcome. Okay. Well, looks like we are live, Madam Hearing Officer, and we have neither of the attorneys online. I texted the advocate and he's on his cell phone, but he didn't, I guess, realize he needed to download the app, I guess. So that's what he's doing.
Okay. Have you heard from the respondent's attorney?
You know, we have been in contact with him throughout the morning. I don't know why he's not here. I expected him to be here. The respondent is here.
Okay.
There's Mr. Markarian. I can get our executive director to stand in for the advocate if we need to do that.
We'll give him just a couple of more minutes if he's trying to download the app and get in.
Okay. Mr. Markarian, will you please do a mic check with me, please? You need to take yourself off mute.
I'm so sorry. 123 ABC 123.
Okay, we are live and you can be heard. Mr. Burdish, would you please do a mic check? I see his icon, but I cannot hear him. Mr. Burdish.
Okay, is that better?
Yes, Mr. Burdish, you have made it. Okay, so Madam Hearing
Okay.
Officer, I guess we can start the meeting or the hearing now. This is case number C-22-0044 with Mr. Robert Shore as the respondent. Mr. Mark Harrion is the respondent's attorney and Flynn Burdish is the advocate for the case.
All right, very good. Thank you, Ms. Levesque. This is Renee Clark. I'm the hearing examiner assigned to this case. And we are here on the advocate's motion to dismiss and issue a letter of instruction. Maybe we should just get everybody like an appearance for the record, the persons who are here who will be speaking, and there may be some others who, like maybe the executive director, maybe some others who are present for the call. So let's just, we'll start with the advocate, and if you would just make your presence noted for the record.
Flynn Burdish, advocate for the commission.
Dave Markarian, counsel for the respondent. I appear today with Mr. Robert Shore, the respondent.
Robert Shore, respondent.
And those are all the participants that are present.
Okay. Okay, very good. All right, Mr. Burdish, I've had an opportunity to review your motion to dismiss. I'll just give you an opportunity to be heard if there's anything that you want to add or that you want to emphasize relative to your motion, sir.
No, I will just stand by what's worded in the motion. I know that the commission and Mr. Markarian worked together to draft that letter of instruction.
Okay. And anything that you want to add, Mr. Markarian?
Yes, ma'am. So we were well on our way to attempting to take discovery that we were hopeful would clear Mr. Shore's name. The motion was filed without consultation with us, but anything that results in a dismissal obviously is a step in the right direction from the standpoint of Mr. Shore. He, in fact, may want to be heard. And I did work with the general counsel of the commission on the language of the letter of instruction, and it is largely acceptable to us. There was one additional tweak to one half of a sentence that Mr. Shore had asked us to consider. I know that he'd like to be heard by Your Honor, But otherwise, I could answer any questions that you might have or respond in any way to anything anyone else wanted to add.
Okay. With regard, you said that there was one addendum that or change that you wanted to make. Was it on the public report and final order of dismissal, or was it on the letter of instruction?
No, it was on the letter of instruction.
Okay. And just to make me aware of what, is it on the, I don't know if it's on the copy that I have or you're making a proposal for amending the copy that I have.
It was purely a proposal. It was, I had worked with Ms. Geiger on one issue, and then after we last spoke, I know that she's not able to be here today. Mr. Shore asked us to ask you to entertain one additional tweak to the language that would be in the bottom of the third paragraph of the letter of instruction, which is also the bottom of the second paragraph underneath the facts section.
Okay. And what is the respondent requesting?
If you can locate in that second paragraph under the facts section, you will see in the left-hand margin, the sixth line down, the words town mayor. It would be to replace the words after town mayor with, to replace the public works director who was sick with COVID attending a scope clarification with the paving supervisor and using the town gas map to identify areas to pave in lieu of the language that's there. I also, I think I mentioned that Mr. Shore did want to be heard if that's appropriate and if everyone has time.
Yeah, no, I'm happy to hear from him. I just needed to know what I was dealing with regard to the proposal, but I'm happy to hear from him.
Okay, so the language, just to repeat, would be after the words town mayor, it would be to replace the public works director who was out sick with COVID, attending a scope clarification with the paving and supervisor and using the town gas map to identify areas to pave. And if everyone's okay with that, we're pleased to work collaboratively to put this matter behind us.
Okay. I think what you're proposing is pretty consistent with what was in the motion to dismiss, at least the facts that were presented in that motion to dismiss. If I'm wrong, please correct me, someone.
I'm just checking. I don't think you're wrong. I'm just checking that.
Yeah. Might be a little more specific on the public works director.
I think you're referring to paragraph 9 of Mr. Burdish's motion, and I think you would be right.
Yes, that's it.
Or perhaps that language, if perhaps we could lift the language from Mr. Burdish's paragraph 9. But either of those, I think, would be
Okay.
Would be something that would make us very comfortable and appreciative.
Okay. Now, and I have another question just before I hear from the respondent. On the letter of instruction, it says in the first paragraph, the second sentence, that the respondent was the former mayor. Is that, or is the former mayor? Is that correct?
That is correct.
Okay.
He's still an elected official. I'm so sorry. I did not mean to interrupt. I was just going to add. Yeah, I'm sorry though. I didn't mean to talk over you. I just was going to add that he is still an elected official in the town, but no longer mayor.
Okay. Okay. Well, let me hear then from Mr. Shore. Mr. Shore, what would you like to tell me?
Thank you for this opportunity to speak. I appreciate the chance to settle this matter pre-trial. I feel this is my first opportunity to present my side of the case to an impartial party, as the evidence I previously submitted is not referenced in any of the orders or letters. And Mr. Markarian just read a paragraph that does clarify the evidence previously submitted. So I appreciate if there is a letter that there is a more direct reference to the evidence presented in writing. I'm charged with corruptly ordering the contractor to, number one, pave a canal crossing from B Road to West B Road, and number two, pave a section of Morrow Court. My involvement in the direction of paving was sharing a highlighted map of all intersections to be paved on B Road, E Road, and F Road as it related to the paving contract that was bid and awarded. Unfortunately, the scope the town put out to bid only listed quantities of canal crossings and intersections or road aprons to be paved. It did not name the roads. A meeting was set up to drive with the paving supervisor and show him the actual roads in the scope of work that was bid. Public director was to attend the meeting, but came down with COVID, so I volunteered to attend the meeting. I used the 2020 town gas tax map as the reference to identify the roads in the scope. This ensured public funds were only spent on public roads and not private roads. Within that scope, there were a lot of private roads, private canal crossings, and I used our gas tax map to ensure that none of those were paved. I took pictures of the highlighted maps that I gave the contractor, and I presented them in my first ethics interview, and they were not received into evidence. I was not able to speak at the evidentiary hearing as my previous attorney approached the ethics board with an improper procedure angle that went over like a lead balloon. I'm asking you to dismiss this case based on unique circumstances in place 2 years ago. The circumstances being COVID, an understaffed public works department. They had 4 employees then, and 2 years later now they have 12. And the poor scope of work written by the town for the bid. All 3 issues noted have been corrected, and no elected official will be put in this position in the future. Please consider dismissing this case with no letter of instruction, and I thank you, Your Honor, for your time, and I respect your decision.
Okay. Thank you, Mr. Shore. I note that in the proposed letter of instruction, they denote that you do not believe that your actions violated the code. And so can you explain to me your rationale for why you feel that the code was not violated by your actions?
Yes, ma'am. The code says corrupt intent, misuse of public position with corrupt intent. And I believe there is absolutely no corrupt intent, no evidence of any corruption whatsoever. This was me helping the town get through a situation. I did volunteer. Should I have volunteered? In hindsight, no, but I did. But there was absolutely zero corruption involved or personal gain by anybody. This was a paving scope that was not clearly identified. It listed quantities. It didn't list the names of the roads. I used a public gas tax map that identifies all town public roads, and I shared that with the contractor, and that was the extent. There was zero corrupt intent or any corruption in this charge. If you read the ordinance, it's all about corruption. And that was my biggest beef from day one. I was born and raised in this county. I sit on a lot of boards. I'm a trustee on boards. I sit on state boards. I have a very good reputation. I'm very well respected in the community, and there was no corruption whatsoever involved in any of my actions that I took on behalf of the town.
Now, it's also alleged, and keep in mind, Mr. Shore, I don't know anything about the case other than the motion to dismiss that was presented to me. But it was also alleged that in addition to, assuming this decision-making authority that was outside of your role at that time, it's also alleged that extra areas were suggested by you to be paved, and that inured to the benefit of others. Namely, they mention in the motion to dismiss certain political allies. How would you respond to that?
Those areas that I identified, which, like I said, I identified them on B Road, E Road, and F Road. I wrote around, I highlighted the areas, the intersections, purely based on the town gas tax map, not who lived on those roads. My worry was that the paving contractor would go rogue and pave private areas, and then the town would be in the pickle because they spent public funds on private areas. So I merely used the town gas map. And these two particular roads that they're referencing, the scope of work said 4 canal culvert crossings and 4 aprons, which is where a side road ties into the main road. In that 1.5 miles on B Road that they paved, there was only 1 canal crossing on the public gas tax map. And that was the one that I identified. There was not 3 other canal crossings. So whoever determined that initial scope was incorrect. And then regarding the aprons, which are the roads to the east, there was only 1 public road that tied into B Road North on that 1.5 miles. And that was the road I identified, purely using the town public gas tax map as a reference. Not just on B Road, E Road, and F Road. That was it, madam. It was as simple as that.
So, if I understand correctly, you were making recommendations based upon this gas tax map, and the areas that were paved were pursuant to that map?
Yes, ma'am. Those are on the town gas tax map.
And were there areas paved that were outside of that gas map?
No, ma'am. There were no private areas paved outside of that town gas tax map.
Okay. Okay. All right, those are really, you've addressed the concerns that I had as I read the motion to dismiss. Is there anything that anyone wants to add?
Yes,
Okay.
this is Flynn Burdish. My understanding was this was an agreement between the commission and Mr. Shore's attorneys that it would resolve with a motion to dismiss and a letter of instruction. Mr. Shore is providing an entire defense, which I don't believe is the object of this hearing.
Well, it would be very difficult for me to make a determination on your motion just based upon the facts that have been presented.
But the allegations there were that he stepped outside the lines of mayor and took it upon himself to do the paving, volunteered, as he says, but there were areas that were paved that were not supposed to be paved. But we also, but when we discussed this, we had already initially, when the case initial resolution was a letter of instruction, because we felt that this whole thing is it was insubstantial. And so that was what we discussed, and we filed the motion to dismiss based on that information as well as other stuff that we thought. And I know that Mr. Markarian and the general counsel from the commission spoke today to change some wording in the letter of instruction so that it would be acceptable.
Well, I'm glad you brought that up, because then that's what I'm struggling with, in all honesty, is how to negotiate the facts as presented in the motion to dismiss, where, according to the motion to dismiss, the facts really allege 2 ethical violations, and which clearly, if proven, fall under the definition of corrupt misuse of official position. And under section 2-260.3 for dismissal of complaints, it has to appear that the alleged violation was inadvertent, unintentional, or insubstantial. And when I read the, paragraph 9 and 10, particularly on the motion to dismiss, on its face, I find it hard to interpret that as inadvertent, unintentional, or insubstantial. So, without more, I'm not comfortable on the motion to dismiss when there seems to be clear disagreement on first of all, the facts as presented, and second of all, whether indeed it was insubstantial. I know that in the, I believe it's the final order, yes, it's the proposed public report and final order of dismissal. It's alleging that the violation was insubstantial, but there's no evidence for me to determine whether it was de minimis or if it was substantial.
So if this is Dave Markarian, if I could be heard just to clarify some of the things that have been raised.
Sure.
The origin of, and Mr. Burdish can correct me if I say anything that he doesn't agree with, the origin of the motion to dismiss and his motion and the suggestion that a letter of instruction be issued came after we had some difficulty trying to schedule the deposition test, the discovery, if you will. We had worked out a schedule, which was fine. And let me parenthetically say, I'm not in any way pointing the finger at Mr. Burdish or the commission. It's just that as we worked out the amount of time that was available to complete the discovery, I think I had supplied 9 dates, full days that would work. Mr. Burdish supplied 3 of those 9 as acceptable, but 2 of them were today and this past Monday. And that didn't allow us even, 5 business days to try to get subpoenas on the folks. And so I was concerned because Mr. Shore, literally since the last time we met with you, no discovery has been taken. And so
Wow.
That is why we're somewhat limited in our ability. And this was not the purpose, I don't think, of the hearing anyway, was to debate the merits or the relative facts of it. At least that wasn't my intention. And instead, I saw Mr. Burdish's motion as an opportunity to try to bring finality to these proceedings. And I think that was his intention. And then I worked with the general counsel's office to try to work to fashion a letter of instruction that would be acceptable to the commission and that also would be acceptable, to Mr. Shore, given that he hasn't been able to take any discovery to clear his own name. And that is, at the end of the day, what really is important to people that offer themselves for public service. They don't make any money, especially in this case. There's no money to be gained. It's a very small town, and it's really a labor of love and a matter of public service. So I saw this, and I still do see this as a genuinely good opportunity for everyone involved to put this case behind us. And I think that was the spirit behind Mr. Burdish's motion. It was after I had spoken to the general counsel and after I believed that we had an acceptable letter of instruction that Mr. Shore asked that you and others consider this one additional change to the letter of instruction to, as you said, substitute paragraph 9 or words to that effect in place of the language that I pointed out earlier. And I still think that's a good idea. It was, and I guess we can hear from Mr. Shore as to where he wants this to land. But I was hopeful that we would have the dismissal occur without debating the relative merits of the case, because we didn't take discovery on that. And I'm confident that the commission didn't bring this action through ill will and, firmly believed in the mission that it has and as it related to this case. It's just that we didn't get to do that discovery. And in fact, if we were not to be able to put this to bed today, we do have an ongoing or existing issue of how do we get the discovery done in time for trial in light of the schedule that we had all agreed upon, and we would need in some form or fashion to expand the time frame allowed to complete that discovery. So I hope that helps to clarify a little bit how we got here. I know that it was well-intentioned on Mr. Burdish's part that we take this path. It was also well-intentioned on our part that we try to find an acceptable outcome. And I just wanted to make that clear in case it wasn't.
Thank you. I can see that, that's probably the intent of the parties. It just, and I'm just looking at the motion to dismiss, and I'm hearing it doesn't seem like the parties are necessarily in agreement. And what it boils down to is, whether the violation was insubstantial. And as I read the facts as presented, and keeping in mind, I don't know anything about the case or the defense, but as I read the facts that are presented, it seems substantial to me. And certainly not inadvertent or unintentional. So on the face of the motion itself, it doesn't seem consistent with the application of the law for the motion to dismiss that the alleged violation was inadvertent, unintentional, or insubstantial. And that's what I'm grappling with.
So, I think I can't really, this is Dave Markarian. I can't really argue the point that you don't have the other side before you, but that's only because we haven't gathered the facts as of yet. There was one deposition scheduled for Monday, which for whatever reason didn't go forward. None scheduled for today. They just weren't schedulable. And the only other day that was available to us was the 24th, next Friday. So I don't know if it makes sense to allow the parties to, and I'm just throwing this out as a suggestion, does it make sense to allow the parties to work together to see if there is an agreement that can resolve this case and to come back before Your Honor in the next 24 hours? Or in the alternative, we need to seek a discovery schedule that will allow us to complete the discovery necessary in the case.
Sure.
And I don't know if Mr. Shore has anything else he wishes to say, but I think those are the two stark options available to us.
I do want to say, Your Honor, I respect your opinion, and you are reading what you're reading, and that's what you're reading. The rest is just, things that I told you. You haven't physically, I guess, seen this evidence. I don't know the process. I don't know, how you have only seen what ethics has put in front of you. So I'm completely ignorant of this whole process, and I apologize for my ignorance. But like I said, I respect your opinion, and moving forward, whichever way you choose, ma'am, that is what's going to happen. Thank you.
Thank you, Mr. Shore. I just want to make it very clear that I know nothing about the case. Nothing's been produced to me. I've got no evidence. I think I've gotten maybe a witness list from the parties and maybe some evidence and that may be presented, but that's it. So I really have no knowledge of the case at all, other than what has been produced in the motion to dismiss. So I think that maybe the parties should meet again and talk through some of these issues. And, I'm happy to entertain anything, that the parties can agree to and present, but my conscience is not satisfied based upon, what I've explained before. So if the parties want to meet and see if they can come to some kind of agreement, whatever that might be, I'm certainly willing to listen and have a hearing on it, and to give it serious consideration. But I'm just very concerned that when I read paragraphs 9 and 10, two alleged violations, violations of the ethical code, and there's an assertion that it was insubstantial, but there's no evidence to support that. And it looks to me, just by reading it, knowing only what I know and not the respondent's position or the defense to the case, it doesn't look insubstantial to me.
So maybe I would make this suggestion. If Your Honor could advise us when you would like us next to appear, we could then work in the interim collaboratively, if that makes sense. And in the alternative, we would need to do some kind of adjustment to the discovery deadlines and schedule if we're, failing that resolution.
Okay, sure. And I'm willing to work with the parties. What's for you guys?
Well, Ms. Clark, if I may, the reason that we made the comment about it being insubstantial was because it didn't cost the town any additional monies. So that was our basis for it being insubstantial. And Mr. Markarian is correct, the discovery process is difficult because I do have a private practice and I'm trying to work around their schedule as well. But we were hoping to put this to bed, and we felt that the inadvertent, unintentional, or insubstantial, the insubstantial was because it didn't cost any additional money.
Let me ask you, it's not just about the money. Is it the ethical violation? Is it paragraph 10 where this allegedly it was done in order to the benefit of specific individuals, including political allies?
Well, that was the finding at the probable cause hearing, and that's what the allegations are, yes. But as I stated earlier, the initial offer to resolve was just a letter of instruction to Mr. Shore that he needs to be, stay in his lane, for a lack of a better term. When you're in a position that you need to follow the rules of the position you're in.
Right.
And that's why when they redrafted, I know that Mr. Markarian and the general counsel from the commission did speak today and did word the letter of instruction in a way that parties felt would be I guess, lack of a better word, a substantial way to put the matter to bed, dismissing the case against Mr. Shore and just putting him on notice that if he is in an elected position, he does need to be careful.
And, this is Dave Markarian. the proffer I would make to you is, this is a small town, the positions are unpaid. And I don't know that I've said this to your honor, but I've told others that are within my earshot today that I have a great deal of respect for the Commission on Ethics of Palm Beach County and its mission. And I think we're a better place for the fact that it exists and it functions. And that is flatly my position. But in a small town, when an elected official who makes no money for their service makes any decision, it's very difficult for anyone to say it doesn't benefit someone, because in a lot of these cases, only a single person or one or two people live on a particular roadway. I also point out, as a part of that proffer, that the initial complaint, if you will, was made by a person who is a political rival. And I don't know that the commission came to any conclusion or adduced any evidence of corrupt intent. It was something that was alleged by a political rival. But I'm also very confident that, and I think this is aligned with what Mr. Burdish has assumed as a part of his motion, is that this paving work was something that Mr. Shore was involved in only because the lone town official, who was the public works official, was out sick with COVID. And several days before the paving was to begin, Mr. Shore interacted with the supervisor of the paving company and used, as he said, the gas tax map to indicate which roads were appropriate to be paved with town money and which were inappropriate to be paid with town money. I didn't want anyone to have the impression, and I would further proffer, that when the paving was done, it's not as though Mr. Shore was out on the roadway telling people what to do or where to go. He was, in fact, in Tallahassee. He was in Jacksonville and on his way to Tallahassee for that annual Palm Beach County Day that occurs in conjunction with the legislative session beginning. And so it was simply him interacting in lieu of the public works official and saying, this is where the roadways are appropriate to be a part of the contract, and this is where they are not appropriate to be a part of the contract. And in that way was a very innocent act of a dedicated public official who is there to serve his community, makes no money from it. And I think, and I don't mean to be argumentative or to serve as a advocate in this, but I really do think that there would be, under no circumstance, a finding of corrupt intent that would have occurred as a result of this, what I consider a selfless act. And so I don't know. I think we're in a bit of a hybrid situation where I think that the advocate was correct in his overall assessment that we were going to spend 3 or 4 days taking discovery, and this was a more appropriate way to resolve this. And the other thing that I think you get a sense of from being here today, this is not a situation where someone is saying that corruption is something that I'm entitled to do, or I am defiant in the face of being called on the carpet. Just the opposite. Mr. Shore has indicated that this is not something he would do again, that the circumstances were unique and special, and simply would like to clear his name with a letter of instruction that doesn't tar him with a brush that is too broad. So I think, and I really apologize for how this unfolded. It wasn't my intention to have it unfold this way. And I think it might make the most sense to allow us to work together for a time certain until we appear back in front of you. And then we have an option of either convincing you that this motion was well taken and it was in the bounds of the the legal standard applicable to the proceeding, or you can help us figure out a discovery schedule that will work. I think that makes the most sense. That's just, my opinion.
I agree with that. I agree with that. All right, so let's do that. How much time do you think you need, Mr. Burdish and Markarian?
Part of our problem is that Mr. Shore's out of the country, and so we've been communicating by, however you do that when someone's out of the country, not the best way. If you don't mind, if I could just ask, Mr. Shore, are you back tomorrow?
No, I get back late Friday.
So I guess then we would flip this back to Your Honor. Would some point on Tuesday be a time where we could get back together, or Mr. Burdish?
Sure.
I mean, whatever you all think is acceptable.
May 21st, Tuesday? Does that give you guys enough time to meet and discuss
I think it
everything?
does. I think it does.
All right, let's do that then.
Did you have a specific time in mind?
How about,
I'm actually pretty good all day, and I'll cancel whatever I might have.
I can't meet Tuesday. I'm in leadership Western Chamber all day Tuesday. And then I have a council meeting that night. So
I think we could probably accomplish it by Monday, if that would work for everyone.
okay. Is that
Or
good?
we could do it
That's good for
later in
everyone.
the day on Monday?
Sure.
Monday, I have a construction industry licensing board meeting at 1:00. So if we did it in the morning,
We'll make
Mornings
that
I
work.
can't do. I
Okay.
can't do a morning, but I can do an afternoon.
all right. My meeting's typically from 1 to 4 at the Vista Center.
Would Your Honor be willing to schedule us at 4 p.m.?
Certainly. Yep.
And I just
That
want to
would
make
work.
sure that's convenient for Mr. Burdish.
Yes, sir. I can make Monday at 4 p.m. work.
Okay, Your Honor, I must also tell you that I really feel as though Ms. Geiger at the commission and everyone there, really tried to help get this behind us, and it was made a little more difficult with Mr. Shore being gone. And I personally will do everything necessary to work with and collaborate with Ms. Geiger, Mr. Burdish, and Mr. Shore, and make sure that we come together with a game plan that I hope will be acceptable and suitable.
That would be great. Definitely, I mean, if we can, I'm on board also. If we can get this resolved, that would be in everyone's best interest. So I appreciate that. So let's reschedule for May 20th, which is Monday at 4 p.m.
Okay, thank you so much, everyone.
All right. Thank you, everyone. I appreciate you being here. That
Thank you.
concludes today's. Bye-bye now.
Thank you.